welcome to everyone. Welcome to everyone here, and now we are recording. So whatever we're going to be doing with this afterwards, this is primarily on a PowerPoint. So I'm going to share my screen and move to the PowerPoint. Yeah, this is the title of this is Estate Planning Basics. It's got a subtitle that was given to me by someone who attended this workshop at one point, how to take the bitch out of obituary. Let's see. Oh, there we go. All right. So a lot of people think that they don't have to plan their estate because they don't have an estate. They don't have a lot of money. They don't have a big house. So they don't think it's necessary to plan their estate. But that's actually wrong. To have an estate, you don't have to have a lot. You just have to have something to pass on when you pass away. So if all you have to your name is your car, and yesterday it was in a wreck and now it's only worth $100, you still have an estate, and that's it. You have something to pass on when you pass away. What can you do to plan to pass your estate when you pass away? Well, there are a lot of things that you can do. There are a lot of approaches that you can take. I can't cover every last thing in this seminar, but I'll cover the most popular things. But probably the most popular thing, the most common thing that people do to plan their estate is nothing. There was an article in, I think it was the Wall Street Journal at one point a little while ago that said almost 2 people out of 3 don't do anything to plan their estates. And I think part of that is that there's some people who just don't think they have enough to worry about, and other people just have trouble dealing with their own mortality. But whichever it is, everybody here is concerned enough to want to learn something. So everybody here, you're automatically in the top 1/3. So congratulate yourselves on that. One of the things you can do to plan your estate is to make a will. And there are different kinds of wills, and we'll talk about those in a little while. Let's see. Okay, hang on. Trying to get my bearings here. Let's see. Another thing you can do is to make a trust, and people have heard about trusts. They're supposed to be better than wills. One of the things about wills is that if you have a will, or whether you don't have a will or not, your estate may go through probate. Having a trust can avoid probate. Another thing that happens when your estate is in probate is that it can take a while. It can take a year or 2, sometimes even longer. I had one person come to me, actually it was a group of people who came to me and said that they had been left some money in an estate by this lady who died, and her estate had gone to probate and they hadn't heard anything. And she died 21 years ago. So I was able to get them their money within 6 months, and delays like that are unusual, but at the same time, they sometimes do happen. So avoiding probate can be a good thing, and using a trust is one way to help with that. Also, because wills can take a while, using a trust can short circuit that time period. You don't have to go to court. You don't have 60, 90, 120-day waiting periods. So using a trust or some other way of avoiding probate can make things run a lot smoother. Another thing about probates is that everything is public record. Everything that's in the probate file is open to anybody who wants to look at it. I filed papers in one probate one time, and I got back to my office, and within 2 hours, I got a phone call from a real estate agent who had read the probate file and wanted to sell the house. I mean, it's that public, which is kind of scary in some ways. When you have a trust, it's all private and nobody has to know about what's in there. So what exactly is in that probate file? Well, your will is in there if there is one. But what else is in there is that your executor or whoever is appointed by the court to be your executor is required to fill out some papers that give a lot of information. And they list all your assets, all your bank accounts, including bank account numbers, all your relatives, all your close relatives, their names, their addresses, and they're even supposed to put down how old they are on the form. It says, how old is this person? So if you have a sister who doesn't want people to know how old she is, you better make sure that she dies before you do, because if your estate goes through probate, anybody can go to your probate file and find out how old your sister is. With a trust, it avoids probate and you don't have any of those kind of issues. All right. So why avoid probate? Well, in addition to what we were talking about, there's a high cost of probate. In California, probate has a thing called statutory fees. The executor gets a fee and the lawyer gets a fee. And the fee in California is basically 2% plus $3,000 of the size of your estate up to $1 million, and then 1% over $1 million. So that can add up to quite a bit of money, and a lot of times lawyers get way overpaid. When you avoid probate, when you use the trust, for example, you don't need as much lawyer services. You may not need any, and you can avoid a lot of that cost. Again, the average probate can take a year or two, can take longer. With avoiding probate, you can avoid a lot of that delay, and all the information is public. All right. So what in the world is probate in the first place? We've heard that it's something that happens when you die, but what really is it? What's it really for? Well, probate is primarily about one thing in particular, and that is that we all have certain kinds of property that have written title, written ownership. So if you have real estate, you have a deed, and you can't transfer title to that real estate unless you sign your name on a new deed. There's money in the bank. You normally can't get money out of the bank, or at least traditionally, without signing your name on something. Or if you want to transfer it to somebody else without signing your name on something, or doing some electronic things that are equivalent to signing your name. And if you have your card, you have a pink slip. And you can't transfer title to your car unless you sign your name on the pink slip. So that is primarily what probate is for, is to take care of that situation, because after you die, you can't sign your name anymore. Well, most of us can't sign our name anymore. So probate takes care of that problem by substituting your signature with the signature of a judge on a court order transferring title to those properties. And that's pretty simply what it is. Now, as long as we're in probate, we're doing some other things too to make sure that all your creditors get paid before your greedy relatives. But this is primarily what it's for. Now, I have a will. People have said that to me. I have a will. It says where my stuff is supposed to go. Why do I need probate? Unfortunately, having a will does not avoid probate because your will doesn't do anything by itself. Think of it this way. Let's say you go on vacation for 6 weeks and you come back and you go to the bank and you try and take money out of your account and it says your account's closed. So you go in and you talk to the banker and ask what's going on. And they say, oh, yeah, well, this guy came in about a month ago and he showed us this document and he said it was your will. And he said you died. And it said that we were supposed to give all your money to him. And so we did. That's what could happen without proper procedures like probate. Probate will help protect against that kind of thing. So having a will does not avoid probate. Now, when I said that your estate will probably go to probate, there is a threshold, and it does change every once in a while, but at the current time, it's $166,250. And if your estate is under that amount, then it may not need to go to probate because the legislature figures, that's too small to worry about. So we'll just let it go. And if people fight about it, then too bad. And if your estate is over that, there are ways to get it under that. For example, if you have bank accounts and you add a beneficiary to your bank account, it'll go to that beneficiary automatically when you die without probate. So it's not counted against that $166,000. If you have a stock account and you have a beneficiary named on that account, so it'll go to that person automatically when you pass away, it's not counted against that $166,000. Until recently, the biggest reason for people to have to go through probate is their house, because who's got a house that you can find for under $166,000? Well, in recent years, the legislature, and it's still a pilot program, but the legislature has been working on this project called the Transfer on Death Deed. You can now essentially name a beneficiary on your house. And when you do that, then the house will go to that person automatically when you die without probate, and the value of the house is not counted against that $166,000 amount. Now, there has been a way to avoid probate with your house before this, and it's called joint tenancy. People would make their children joint tenants on their house, and when they died, then it would automatically go to their children without probate. But there are problems with joint tenancies. One of the problems is that when property is in joint tenancy, it actually becomes owned by your joint tenant. Your joint tenant becomes a full owner. So if you ever want to downsize or sell your house, you have to get your kids' permission to do that if they're a joint tenant. Also, if they're a joint tenant, because they're a full owner of the house, if they get into financial trouble, their creditors can get at the equity in your house while you are still alive. So if your kid gets into a traffic accident and they're in a hospital for 6 months and they run up $2 million in medical bills. And you only have $1 million of insurance. The hospital can come after your house because your kid is a joint tenant. So a transfer on death deed avoids all of those problems, but still allows you to avoid probate transferring your house. Okay, so we've heard of trusts. Trusts are one way to avoid probate. We've heard that they're better than probate. We've heard that they're good, but what really is a trust? What's it for? How does it work? Well, I like to think of having a trust as like having your own private corporation, because legally they're essentially the same. A corporation doesn't actually exist. There's nothing you can look at or touch that is a corporation. Corporations own property, but the corporation itself doesn't really exist. But the law says that if you have the right paperwork, then we'll pretend there's this corporation and it's allowed to own property and transact business and do a lot of things that people can do. A trust is the same way. There is nothing tangible about the trust, but if you have the right paperwork, then we will pretend that there is this entity called a trust, and it can own property and it can transact business. If you set up a trust, it will own your property and it will transact your business. That's how it works. The trust only works for what it is the legal owner of. So if you set up a trust but don't transfer ownership of all your assets into the trust, it will not work to do anything, including avoiding probate. Okay. Now, a corporation is run by its president. The president is in charge of the corporation, is responsible for signing all the contracts, for paying all the bills, for doing all the business of the corporation. Presidents can delegate authority, but the president is really the one who is ultimately responsible and in charge. A trust has someone exactly like the president of a corporation, and that's called a trustee. If you have a trust, you will be your own trustee. So you will, in effect, be the president of your own corporation, and your corporation will own all of your stuff, and you will still be in charge of it because you are the trustee. You are the president of your corporation, and the corporation owns all your stuff. So how does a trust work to pass property when you die? I'm going to use an example, but I'm going to talk about a corporation, not a trust. Let's say there's a small corporation, got one owner, and the corporation has a dozen employees, and every week the president's secretary brings him payroll checks. He signs the payroll checks, and everybody gets paid on Friday. Seems like a reasonable thing to do. Well, this particular Thursday, the president's secretary brings him the payroll checks. He picks up his pen, starts to sign, but doesn't have a chance to sign any of them. And he hears this loud banging on the door. Well, he's a little surprised because he's not expecting anybody. So he goes and he opens the door to his office, and he's blinded by this bright light shining in his eyes. And he can't really see anything. So he steps back to see if that can help. And the light is so bright, he still doesn't see anything. But he can hear somebody say, "My name is Anderson Cooper, and I'm here to ask some questions about your corporate practices." Well, he wasn't expecting that. He didn't want that. He feels a little weak. He falls back in his chair, has a heart attack, and dies on the spot. we can tell that we have a problem here. In addition to the problem of the dead guy in the chair, the problem is we have a whole bunch of employees who want to get paid tomorrow. And the only person whose name is on the signature card who can sign those payroll checks just died. So what can we do? How do we get those people paid? Well, in a corporation, there is a person who is, by law, the person who takes over when a president dies. That is a vice president. The vice president automatically becomes the new president. As the new president, he issues a letter to the bank telling them that there's a new president. He goes down to the bank, gets his name on the signature card, and he can then go sign those checks, and everybody gets paid on time. A trust has somebody exactly like a vice president. We call him a successor trustee. When the original trustee dies, the successor trustee becomes the new trustee. Now, just like how the vice president in the corporation had to do some paperwork when he became the president, the successor trustee has some paperwork too. The successor trustee has to show people two things to validate his being the new trustee. One of those things is a notarized copy of the trust, showing that he's the next one in line in the trust document. The other thing that he has to show them is a certified copy of the other trustees, the old trustees' death certificate, to show that person actually did die. And those two things together make that person the new trustee, and then he can do whatever he needs to do to follow the trust rules to distribute the trust assets. Okay. Now, in estate planning, there are some other issues that people run across as they're doing their estates. One is that some people like to leave something to charities. Now, if you want to leave something to a charity, that's great, but you need to be careful. And a lot of people don't realize this, but if you ever go to the IRS website and look up approved charities, you'll find a ton of lots and lots of charities, and you'll find a lot of them have similar names. So if you're not really careful in making your gift to a charity, it might end up going to the wrong charity. I've seen it happen. There was one case a bunch of years ago where a lady from Connecticut left a rather large gift to a university in California. And nobody knew why she did that. She never lived in California. She didn't have friends in California. She didn't go to school here, neither did her children. I mean, she had no contact that anybody knew of with anybody in California. But she left in her will, quote, $5 million to the University of Southern California, also known as UCLA. If you don't know that already, those are two different schools, USC and UCLA, and both of those schools decided they wanted that $5 million. So they sued each other. And this lawsuit went on for 7 years. They sent people they sent lawyers and they sent investigators to Connecticut to interview people and do research and try and figure out which school that lady really meant. After 7 years, they still hadn't figured out which school she was talking about. And after 7 years, half of that money was already gone in lawyers' fees. So at that point, the two schools decided to just split what was left. But the bottom line is that the school she actually intended to get her money got 1/4 as much as she wanted them to get because of that little mistake. So be careful when you do that. Where do you keep your will? People ask me that a lot, and you want to keep your will in a place that's safe, a place where you keep your other important papers. You can get a fireproof, waterproof safe. You can get small ones, 9 by 12 inch fireproof, waterproof safes. You can get them like at Home Depot or Costco, something like that, for about $50 or $60. You can get larger safes for a couple $100 that'll keep your documents safe. Excuse me.
It's 5 p.m.
One place where you do not want to keep your will is in a safe deposit box. And why don't you want to do that? The reason is that if you normally, the only person who can get into that safe deposit box is you. And after you die, nobody can get into the safe deposit box without a court order. So unless there's somebody that you allow to get into the safe deposit box while you are still alive, nobody can get into it after you die without a court order. And if you have a will in your safe deposit box, you can't get a court order without your will, and you can't get the will without your court order. And so there's sort of a little problem there. There was a case years ago in San Francisco. This was when Neptune Society first got started, and cremation wasn't new, but it was sort of new to modern society. It was very unusual, and Neptune Society wanted to change that. And so they made a big deal about cremation. They advertised it a lot. They tried to make it a lot more acceptable than it had been. I remember an article on the front page of the Sunday Chronicle talking about the Neptune Society getting started in the Bay Area. And there was this one family that got together to have a family meeting to talk about it. And everybody in the family decided they loved the idea of cremation. It was a lot cheaper, it was more environmental. Everybody thought it was a good idea except the dad. The dad was just really creeped out by the whole idea of the Neptune Society or of cremation. But he was one of these people who just would sort of go along and get along, didn't want to rock the boat. So he didn't tell anybody because he thought it would cause trouble in his family. But what he did do was he went to a lawyer and he had a will draft that said, "Do not cremate me." Well, your will really doesn't do anything other than distribute your assets. So saying "do not cremate me" in your will really doesn't do a whole lot. So to put teeth into it, he wrote, "If I am cremated, my family gets nothing." Nothing. As a way to try and prevent them from cremating him, which sounded like a good idea at the time. But then what did he do? He still didn't tell anybody. He took his will and stuck it in a safe deposit box that nobody found until 6 weeks after he was cremated. So safe deposit box is not the best place to keep your will. Amending your will. Wills can be amended. These days, with word processors, we usually just make small changes and and reprint the document, but you can have an amendment to your will, and the amendment is called a codicil. Now, in California, we recognize two different kinds of wills. There are formal wills, which can be typed or printed or handwritten or any combination of those things. And formal wills have to have two witnesses. And then we have a thing called a holographic will. A holographic will is a will that's all in your own handwriting. It has to be dated at the top, signed at the bottom, and in the middle you say where you want your assets distributed when you pass away. And the great thing about a holographic will is that it does not need to be witnessed. But you have to be careful. Wills have a long history in the law, and there are a lot of little nuances that people don't realize that if you aren't careful, you could violate and could cause trouble. For example, your will has to speak in the present tense. This is a problem I've seen with a lot of holographic wills. People write them in the future tense. They write down, when I die, I will leave my car to my friend George. Well, you don't want to do that because you're speaking in the future tense instead of the present tense. Your will speaks of the time after you pass away, so it has to be in the present tense, or a court may not accept it. There was a situation where there was one guy who did his own holographic will, and he was a smart guy. He went to Stanford. He enjoyed Stanford, got a really good education. So he was pretty smart. After he got out of Stanford, he got a great job, did really well. He was really grateful to Stanford for all they had given him. So at one point, he went on their board of directors. And as he got older, he decided he wanted to write his will, and he wanted to leave a gift to Stanford to thank them for everything that he had done. But again, he was really smart. He was too smart to have to go to some lawyer to write a will for him. He knew about holographic wills. So he wrote his own will, and in it he wrote, I leave $100,000 too. And then he was going to write Stanford, but the legal name for Stanford isn't Stanford, right? If he just wrote Stanford or even Stanford University, it might have gone to the wrong place, because the legal name for that university is the Leland Stanford Junior University. That's a mouthful. I suspect he came to that point and didn't want to write out that whole thing. Maybe he thought there was too much, it would give him writer's cramp, or who knows. But since he was on the board of directors at one point, he had a rubber stamp that said the Leland Stanford Junior University. So he wrote, I'd leave $100,000 too, and then rubber stamp, the Leland Stanford Junior University. When he died, they did not get one penny. Why? Because that part, their name was not in his handwriting, which is required of a holographic will. So if you do a holographic will or a holographic codicil, be careful. Now let's go back to trusts for a minute, because trusts are currently the most popular way of avoiding probate. And trusts also do some other things. Trusts allow you to keep control to an extent, even after you die, if you want to do that. So if you have, say, a grandchild who can't handle money, you can appoint someone as a trustee for that person to handle their money and only distribute what the grandchild needs or what the trustee thinks the grandchild should get, to make sure that person doesn't go and blow all that money all at once. I've seen it happen. I saw one kid whose mother died. He inherited a bunch of money. He thought that it was more than it was. He received a check for $250,000. He thought that that was half of what he's going to get. So he went and he took that money and he bought a car with it, $250,000 car. And then he went and totaled the car. And he was expecting to get another $250,000 and he didn't. So that's one thing that you can do with a trust. It doesn't have to distribute the money and property after you die. It can stay in there as long as necessary if you have this kind of a situation. When there are children from prior marriages, a trust can help with that too. I've seen a lot of situations, well, not a lot, but a lot more than one, where people are on second marriages, where there are kids from prior marriages, where the couple set up an estate plan where I leave you everything when I die, you leave me everything if you die first. But then after we both go, everything gets split equally among all of our children. Sounds like a great plan. But sometimes, if I die first, my wife, my widow, can change her will. And I've seen people do that. So my kids get nothing and her kids get everything from her side and my side. So with a trust, you can prevent that from happening and make sure that if your plan is to share everything with all of your kids equally, you can do that. Grandchild's college fund, I was talking about that. If you want to have, make sure that your grandchild goes to college, for example, you can give them money to do that. But if you give a 19-year-old or an 18-year-old $300,000 or $400,000 in cash and tell them it's for their college, is that what they're going to use it for? Probably not. So with a trust, you can keep that money under the control of somebody who you do trust to make sure that the money is used for the purpose that you intend. Now, estate planning isn't for just after you die. There are some situations while you're still alive that your estate planning can really help for. And these are some documents you can find on my website. What happens if you're temporarily disabled and you can't manage your own finances for a while? You break both of your arms, you can't write checks, you're in the hospital, you can't manage things. You can appoint someone as a power of attorney to do that for you until you are ready to come back and do it yourself. The alternative to a power of attorney is a thing called a conservatorship. And with a conservatorship, you have to actually hire a lawyer and go to court and ask the court to take control of your assets, of your finances. And there are a whole lot of things wrong with conservatorships. One is having to hire a lawyer and go to court. That can get expensive. Takes time because the courts are all backed up these days. And the biggest problem of all is that when there's a conservatorship, not only does somebody else get the right to handle your affairs for you, but you lose the right to handle your affairs for yourself. So let's say my mother has an accident, she goes in the hospital, I want to go help her. but she doesn't have a power of attorney. And so I go to court and ask a judge for conservatorship, and the judge looks at me and he says, well, you live in a different county from your mother, so I'm not going to let you be her conservator. I'm going to appoint one of my golfing buddies. And he does. And not only is his golfing buddy the conservator, but that person charges my mother $150 or $200 an hour for doing that job. Even after my mother is feeling better, until we can go into court and get the judge to lift the conservatorship, only the conservator has power over her finances. So if my mother is feeling a little better and wants to go shopping, she has to call the conservator. He gets in his car, drives, picks my mother up, goes to the mall. She spends some time shopping. But then who pays for it? The conservator has to come up and pay for it with my mother's money because she doesn't have the legal right to do that anymore. Then he takes her home and sends and writes himself a check for all those hours that it took him to take her to the store and take her back, and for him to get there and for him to get back to his office. I would have done it for free, but no, we had to hire a conservator. So having a power of attorney is a really good thing to do to avoid that problem. And what happens if you're permanently disabled? There's a document called an advanced directive for healthcare. It's like a power of attorney, but for your healthcare rather than for your finances. And primarily what that is for is to help determine what happens if a doctor says that they think that you're brain dead and there's no hope for recovery. Some people say, I believe in miracles. I want them to do everything they can to bring me back. And other people say, I don't want to just be on life support for years and years with no hope of recovery. Which one is up to you? If you don't have this healthcare directive, then that decision will be up to somebody else who you may not know. There have been cases over the years. The most recent one I recall is a lady in Florida named Terri Schiavo, but there have been others where a person gets into that situation where the doctors think that they may be brain dead or there's no hope for recovery. And in Terri Schiavo's case, her husband knew that she did not want to be on life support with no hope of recovery. And her parents thought, oh, well, we believe in miracles. We think she's going to come back eventually. And this went through the courts. It went to Congress, for God's sakes. I mean, people argued about this for a long, long, long time. Finally, she was taken off life support, and an autopsy determined that her brain really was unrecoverable. It had shrunk to half its normal size. If she had had this advanced healthcare directive, she could have directed the doctors to take her off life support if they thought that it was a good idea, or she could have appointed her husband to make that decision for her rather than leaving it up to some fight within the courts. So it's something that you should consider too, whichever way you want your life handled. If you get in that position, you can instruct someone how you want that handled, and you can appoint someone you trust to do that for you, to make sure it's done the way you want it handled. And I think that's it. So let me see. Okay. So, Darlene, do we have some questions?
Yes, we do. So JP and I were just discussing. Okay, it's not too bad. So we'll get out of here on time. Somebody asked, can you help people that got involved in a Ponzi scheme? That's not really on topic, but I guess that's a yes or no question.
Can I help somebody who's been involved in a Ponzi scheme? I'm probably not the best person, but if someone wants to call me, I might be able to direct them to somebody who can help.
Okay. Remember, that's downtoearthlawyer.com. So you can reach Stu Bronstein that way. All right. The next question, JP, you want to take this one?
Yes, the next question. Can a foreigner, not a US citizen or green card holder, be a beneficiary?
Yes, absolutely. Someone who's not a US citizen or a green card holder can definitely be a beneficiary.
Okay.
And children can be beneficiaries. Children can be your own executor. If you want them to do that, that happens frequently. So there are very few actual restrictions from that standpoint.
Okay, can you also talk about the tax consequences between a corporation and a trust?
Tax consequences. Well, while you're alive with a trust, trusts are transparent for tax purposes, for income tax purposes. Everything that is in your trust, if your trust earns money, it's treated as if it's your money. It goes on your social security number. And so it's exactly, for most financial purposes, it's like the trust doesn't really exist. If you have an irrevocable trust, it's more like a corporation, and it is its own separate tax-paying entity most of the time, but you do not want to use an irrevocable trust that way, because irrevocable trusts get into the highest tax bracket at only $7,500 of income. So you don't want to use an irrevocable trust that way if you can avoid it. These days, corporations, I think, have a top tax bracket in federal tax of about 21%. So there really isn't any correlation from a tax standpoint between corporations and trusts.
Okay, the next one, a little off topic. I'm not sure if you have an answer, but a friend just moved into subsidized senior housing. Many of her fellow residents drive luxury cars like old Mercedes-Benz, etc. How do these one-time wealthy neighbors hide their assets to qualify for subsidized housing?
Every county has its own rules, and it could be that the rules in that particular county just look at the person's income during that year rather than all their assets. So you need to look at what the rules are in that county. You might want to call your state legislator and see about some rules at a state level that will make more sense.
Okay, what if you set up a trust and then you get married?
Then it's a really good idea to amend your trust or create a whole new one. You don't have to, but there's a problem potentially, because once you marry in California, any money that you earn, and I'm saying earn as opposed to receive from passive income, is community property. So you don't have control over your spouse's half of your community property. And if it goes into your trust, then it can cause everything in your trust to become community property. And it can cause all sorts of problems. So yeah, if you have a trust and you get married, it's a really good idea to amend the trust at the very least to bring your spouse in as a co-grantor of the trust.
Okay, next one. How do I initiate a transfer on death deed?
There is a document called a transfer on death deed. And if you look at my website, you'll find it. It's got instructions on the back. And what you need to do is to get your current deed so you can have the legal description, fill out the transfer on death deed, have it notarized, have it recorded with the county recorder where the property is located. You have to do that within 60 days, and then you're all set. And one of the great things about the transfer on death deed is that you can change it at any time if you want to do that. So if you leave your property to 3 of your kids, and one of them later becomes a drug dealer and you want to not leave the property to him, you can do that. So, so you will find that document on my website. Go to downtoearthlawyer.com, click on the link that says free forms. You'll find a thing called the statutory will, which is the California legislature's attempt to give you a will that you can fill out yourself. There's also a statutory power of attorney and statutory advanced healthcare directive. And those forms are actually pretty good. You can fill them all out yourself.
Okay, I've got one. It went straight to me, so no one else can see it, but it says, can co-signers on bank safety deposit boxes access the box after the death of the owner?
That's up to the bank's procedure. You have to check with the bank exactly how they have it set up. Just being a co-signer may not be enough to give you access to the account. You actually have to have a key, and you have to be specifically authorized to have access. But yeah, you can get specifically authorized. It is potentially possible to have more than one person authorized to access the same safe deposit box. So you can do that.
Okay, next one. What if you move out of state after setting up a trust in California?
Well, one of the great things about a trust in the US is that the rules are pretty much the same every place you go. So if you set up a trust in California, you can use the same trust even if you move to another state. So you have a trust in California, the trust, say, owns your property. You can have the trust sell your house in California and move to Nevada or move to North Carolina and buy a house there with the trust. So again, it's like having a private corporation, and it's the corporation that owns everything, and you can take that pretty much any place you go. Now, if you want to go outside the country, that's a little different. Trusts are recognized in English speaking countries, but not very often in non-English speaking countries. So if you're moving to a non-English speaking country, or you have assets in a non-English speaking country, then that needs to be dealt with in a different way. That can get a little complicated, so we won't go into that today.
Okay, I think this is in a similar vein. If you have your house, upon transfer of death, do you put the house in your trust? If you have your house in transfer of death, do you have your house, put your house in trust? I'll let you try and figure that one out. Does that make sense?
Yeah, you don't do both. You either use a trust and the trust determines where your property goes, or you use a transfer on death deed and that deed determines where your property goes. you can't use both. It just won't work.
All right, next one. Do you put your car title in the trust?
That depends. Remember that $166,000. You have to look at that. I want to keep the amount that's not in the trust as low as possible, because sometimes things happen that increase the amount that you have that's outside the trust. So my personal rule of thumb is that if it's an expensive car, if it's a car worth more than, say, $40,000, I would put it in the trust. If it's worth less than that, then it's not necessary. But remember, you want to keep all the assets that do not have a beneficiary under $166,000 or under $100,000 even, and use that as sort of a rule of thumb.
Okay, I have another question. I apologize. The library announcement is playing in the background. Can you hear me okay?
Yeah, I can hear you fine.
Okay. If your sons have their signatures with the safe deposit box, can they get in after the death? Can they get in? So similar to last question that we had about co-signers on a safe deposit box.
Yeah, again, this is up to the bank's procedure. Bankers like to make up rules that don't actually exist. And they do it because they think it protects them and their customers, even though it doesn't always. So you really need to check with the bank to see what they require.
Okay, next one.
This is not a legal question. It really, it's up to a bank procedure question. I'm sorry.
No, fine. Sorry about that. What's the best way to write up your own will?
The best way, personally, I would start out with the California statutory will. It's set up in a way that makes it pretty easy. It's a little more complicated than it should be. So if you want to do that, read through the whole thing before you start to fill it out. You can do a holographic will, but there are some pitfalls with that. But that's another way to do that. Holographic will is simple. You just take a piece of paper, handwrite the date at the top, say where you want your stuff to go, and then sign it. And that is your will.
Okay, moving right along, how to find legal help with estates, trusts, etc. Well, if you're here listening, that's step one. Do you have any other advice?
There are different ways to find good lawyers. The San Francisco Bar Association has a lawyer referral service. You can call them. They have they'll give you the names of some lawyers, and lawyers won't charge you anything, but there is a fee. Last time I checked, it was like $25 that the lawyer is supposed to collect from you that pays the Bar Association for their service. You can find lawyers on, this is actually a good website. It's called lawyers.com. It's run by another website called martindale.com. It has almost every lawyer in the country on it and what they do. But the good thing about lawyers.com is that for a lot of lawyers, it has ratings, has separate ratings from other lawyers and judges in their community. And sometimes you'll find ratings from their customers, from their clients. And if you find someone who does what you need to do and they have good ratings from other lawyers and from their clients, that might be a good person to go to.
Okay. Here's another one. If you set up a trust, you have to change your checking account to say the trust of Joe Schmo.
Yes, you should do that. That again, that's up to the bank to exactly how you do that. Some banks will want you to open up a whole new bank account. Now, you can have large bank accounts in the name of the trust and a small bank account. If you use a small bank account for routine purchases, you can have that maybe up to $5,000 or up to $10,000. That's not in the trust. Because again, you want to keep what's not in the trust down to, well, let's see, down to under $160,000 or under $100,000. So you can do it that way. Have a small account that's not in the trust, but put your large accounts in the trust, and then you can transfer money back and forth, generally online.
Okay, I think this is a quick one. How's the limit of untaxable for inheritance?
At the current moment, there is a combined gift and estate tax, but it doesn't kick in until you have given away at least $12,060,000. So for most people, this is not going to be an issue because most people never come anywhere near having $12 million. Now, for people who live past 2025, that number is going to be cut in half. The amount does increase with inflation, but the current law says that amount will get cut in half in 2025. So for married couples, they'll still have $12 million that they can save tax-free, but for individuals, it'll be about $6 million or a little bit more.
Okay, next. Is there a good book to read through for more information on setting up a trust or will?
I like Nolo Press. Nolo Press is a Berkeley self-help legal publishing company that does a really good job with a lot of things. In fact, I know lawyers who set up trusts for people using the Nolo Press trust book. So that would be where I would go. You can catch them at nolo.com. That's NOLO.com. There are a lot of bookstores that carry their things too, but that would be the first place I would start.
And of course, the library has a lot of Nolo Press books as well. So
Oh yeah,
visit your local library.
good idea.
Looks like, is a revocable trust, does it become irrevocable after the spouse dies?
Trust is revocable because the person who sets it up can change it or revoke it. So when that person dies, it becomes irrevocable. So I'm not sure exactly what that question means, but if a married couple sets up a trust, they can do it in a couple of different ways. They can have it set up so that when the first spouse dies, their half goes into a separate trust that then becomes irrevocable, but the surviving spouse can get all the income from it, and the surviving spouse can even manage it. But then when the surviving spouse dies, then the second half of the trust also becomes irrevocable. Or they can set it up so that when the first spouse dies, everything is given to the second spouse, goes into the second spouse's trust in essence, and that is revocable until the second spouse dies, and then it becomes irrevocable at that point.
All right, and there's a follow-up to the beneficiary taxing. Is 12 million untaxable for a foreign beneficiary as well?
Yes. The issue is who is giving the property, not who is receiving it. So the taxes, and this is estate tax, not income tax. The tax is on the person who's making the gift. So the $12 million can be given to anybody and there's still no tax. Now, if you have somebody who's not a US citizen and they have property in the US that they're giving away, then basically that $12 million exemption does not apply. At most, there's a $60,000 exemption, and the tax kicks in at around 40% over $60,000. So if somebody's not a US citizen, then there are other ways of dealing with this to make sure that the tax is not imposed unnecessarily. In the situation where there's a married couple and one is a citizen and one is not, that's another kind of tricky situation, though there is a relatively easy fix for that, because what happens in that case is the surviving spouse can give an unlimited amount to the other spouse. However, if the other spouse is not a US citizen, then everything over the $12 million might be subject to tax unless you set it up with a trust that makes sure that when the second spouse dies, the government's going to get whatever tax is owed to them at that point. They want to make sure that if there's a surviving spouse who's not a US citizen, that they're not going to take everything and go out of the country and avoid any tax that would have been paid. And there are ways of making that happen. I hope that's
Okay.
clear.
I hope so too. Looks like that's it. You've got some thanks in the chat, and I want to thank you. This was wonderful and informative as always. For everyone who's listening, a follow-up email will be sent tomorrow. We have to wait for the recording to process and get everything together, but you will be receiving that. Stu, I want to thank you for coming today. It's always
welcome.
interesting hearing this. I've heard it a few times and every time I learn something new. So everybody, thank you for coming. Thank you, Stu. Thank you to JP for helping out today. And I want to wish everybody a wonderful evening. And we'll see you all soon.
Thanks, Doreen.
All right. Bye-bye.